Hi, y'all, and welcome to tonight's live stream. It is already a case that has sparked controversy across the country. Should James Crumbley be held liable for a murder that his son committed? And now we have a new question laid on top of it, which is, did James Crumbley try to influence or even threaten witnesses? So happy Friday, everybody. I hope you are looking forward to the weekend. I know I am. Gibbs Gardens is finally open again. I am thrilled to say, and I'm hoping to get over there this weekend. I'll bring back some pictures to show y'all on Monday night if I get over there. So James Crumbley is on trial for involuntary manslaughter of 4 high school students. No one says he picked the gun up himself, but everyone agrees that his son did. James's wife, Jennifer, has already been convicted of involuntary manslaughter, and now James is on trial himself in Michigan. So as we're getting into it, I would appreciate it if you would hit the like button. It'll get the video out to more people, and subscribe. We would love to have you back. We go live Monday, Wednesday, and Friday at 7 p.m. Eastern. And a special welcome to our first 5 in the live chat tonight: Cognac Kobo, Carol Sue, Tennis Girl, Denise, and Jeb. Shout out to all of you. So here's the story of what happened. It's something out of a horror movie, frankly. On November 30th, 2021, a figure clad in baggy clothes emerged from the men's bathroom at Oxford High School, shoulders squared, carrying a Sig Sauer handgun. For the next 9 minutes, he strode up and down the hallway, wreaking total terror on children and teachers. He shot 32 times, wounded 7 people, and killed 4 young people. The shooter was Ethan Crumbley, and he killed 4 people that day, 4 beautiful young people who had done nothing to deserve what happened to them. Justin Schilling, 17 years old, Hannah St. Julia, 14 years old, Madison Baldwin, 17, and Tate Meyer, 16. Now, we're going to cover 4 topics tonight. One of them we may have to shorten if we start to run out of time. The first thing I want to talk about is the big controversy around the case, what it is, and how that's going to affect the trial. The second is the brand new controversy about threatening witnesses. The third thing I want to talk about is the opening statements. And then the fourth, which we may have to cut a little bit, is what's happened at trial so far. And I'm going to take it through noon today. As you know, I'm always slightly behind. So the controversy around this case, but I'm always slightly behind because I try to stop so I can get ready for the live stream. So I stop watching so I can talk to you about it. Ethan was only 15 years old when he committed these murders, but he has been sentenced to life in prison without parole. So he will never get out of prison. But the controversy is that Ethan is not the one on trial here. It's his dad, James Crumbley. James did not go to the school, pick up a gun, and shoot people that day. He didn't know Ethan planned to shoot people, and everyone acknowledges that. But he is still on trial for involuntary manslaughter for the 4 students who died that day. Here's what the prosecutor said about it, and you should know it's controversial, and you are free to reach your own opinions about it.
Who committed murder, no doubt he's responsible.
He's talking about the
So are his
shooter.
parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder.
Now, that is an argument more common in civil cases than in criminal cases. It is controversial to hold parents liable for the crimes of their children. let's talk about the legal theory that the prosecution is using in this case. They have two alternate theories that they're giving to the jury. In order to convict James Crumbley, the jury was told, every one of you has to believe one of these two theories, but you don't have to all believe the same theory. You could believe different ones if you wanted to. So, and now we're going to hear the judge talk about it.
The defendant is charged with 4 counts of involuntary manslaughter. The prosecutor has alleged 2 separate theories of defendant's guilt, which may be established under either or both of the two theories. The first theory of involuntary manslaughter is doing a grossly negligent act causing death. The second theory is gross negligence in failing to perform a legal duty. With respect to the alternate theories, it's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt.
Now, that's exactly those theories are, because they're frankly kind of technical and difficult to understand, I think, and ultimately the most important thing to deciding the case. That's what really matters here. So more than any other case we've covered here on the channel, this case is about the legal theory more than it's about the facts, because the facts are widely agreed on. What isn't agreed on is whether that legal theory fits. So many people believe that committing James Crumbley for a murder his son committed, or convicting him for a murder his son convicted, is just wrong. So I want you to understand what the legal theory is, and you are free to disbelieve it. Theory number 1 is doing a grossly negligent act causing death. So it has to be something more than just James Crumbley was careless. The judge told the jury it has to be more than he was just he has to have fully been grossly negligent, and the judge defined that as he knew of the danger and he could have avoided it by exercising ordinary care. There was something he could have done about it, and he failed to use that ordinary care, and it was apparent that the result was likely, not just possible, but likely to be serious injury. So that's theory number 1, doing a grossly negligent act causing death. Theory number 2, gross negligence in failing to perform a legal duty. And here the judge explained that James Crumbley had a legal duty under Michigan law to exercise reasonable care to prevent his child from intentionally harming others, and the prosecution also has to prove that James Crumbley knowingly and willfully neglected or refused to perform his duty. So notice the knowing and the willful part of that, and that it was apparent that there would be likely to be serious injury in the other theory, and that he could have avoided it by ordinary care. So that's the theory that they're going on. And here it's more important than usual. Usually we focus more on the facts and less on that, but here it's central to whether or not the prosecution can or should win. Now, I want to talk a little bit about the brand new controversy, which is threatening witnesses. When you look at James Crumbley, he seems like the last person you would expect to be threatening witnesses. He just doesn't look like someone who would do that. It just doesn't match. But at the end of the day, yesterday, on the first day of trial, the prosecutor stood up to make a motion, and the defense objected to it even being brought up. I have cut this way, way down, but you can clearly see that everybody's talking in code, and that no one seems to want to put anything on the record with the media there. That's the defense lawyer, that's the prosecutor, and that's the judge. Nobody wants to do that. So let's watch and take a look at what is said there. Sorry, give it just a second. It'll flip over to the next.
Before we get started,
Would we call this a motion? Is that?
Judge, I think it is. It's an oral motion.
Your Honor, before we get started, I'm just going to place
This
my
is the
objection on
defense
the record
lawyer.
that this is being handled.
And she confused everybody by saying she objected that this is being handled. What she meant was she objected to how it was being handled. So that caused a moment of confusion there in the courtroom.
That this is being handled?
Yes, especially in front of the media in the middle of a trial, when this is obviously very likely going to be put out in the public, Your Honor.
Well, I do have a concern about that.
Judge, I was
She's
not
concerned too.
asking for it to be in front of the media, but I don't know how to make a record without that. Madam Judge?
Well, I guess I'm wondering, during the course of the trial, if there's any kind of a stipulation that could be agreed to. I think the situation could be temporarily taken care of with a stipulated order, but I don't know if that's satisfactory or not. I'm reluctant to impact the rights of the parties during the jury trial.
I mean, Judge, my request is pretty straightforward, and it's pretty time limited.
Well, I know what your request is, but I'm concerned about statements that might be placed on the record, right? Aren't I concerned about that?
I am, Your Honor.
I mean, Judge, I think it's appropriate for the record, and obviously the jury's not present, that's why they're not here. But I understand what the court's raising. I'm not.
All right. Well, I know you do. I know you do.
We're just talking about during the pendency.
So, okay, everybody, as you can hear, is talking about how they don't want to talk about whatever it is. And they're tiptoeing around. Remember, at this point, no one has any idea what they're talking about. In fact, it was really interesting because I had to look at only a few of the websites that carried the trial actually even included this. Most people turned off when the last witness left and nobody was around. It was hard to even find these little clips that I could give you because nobody thought this was really all that important or had any idea something was about to happen. So what the judge has thrown out is, hey, maybe we could just reach an agreement so we could keep this off the record. And the prosecutor's having a hard time because the prosecutor's saying, well, I have to make a record. I have to say something. And so at this point, everybody tries to get James to agree.
The trial.
Okay. The client's shaking his head.
The client shaking his head. I don't
Your
know
Honor,
what to
my
do.
client is not willing to agree to the order.
Okay, so there were a lot of pauses in there that I cut out just to make it a little bit shorter. But the prosecution made it so they're trying to get James to agree to something. The idea being, if we just put a quick stipulation on the record that everybody agrees to this, we won't have to go into any detail and discuss this in front of the media. But the prosecution made it real clear they wanted to ban James from talking to anyone, James Crumbley, from talking to anyone other than his lawyer and clergy, and legitimate clergy at that, they specified.
I mean, Judge, if the order gets entered, we're asking that the communications be limited to only counsel and legitimate clergy during the rest of the trial. That's my request. We're talking 7 or 8 days. You can talk to his attorney, you can talk to legitimate clergy.
Okay, so if he doesn't agree to it, then the prosecutor is going to make their motion. Right?
And I have advised Mr. Crumbley of that, Your Honor. I would propose that there could be a different order with a restriction and not a complete revocation. Obviously, the prosecutor's office is reviewing communications. They would know whether or not the order was violated, and at that point, if the court needed to take action, then the court could take action.
Judge, it's not just about violations going forward, it's about the conduct that's already happened.
Well, I understand that. I understand that. It's so hard to understand because there's a big old sign right there, right?
It's on every call. Every single call.
Yeah.
So the judge is almost surely referring to the large placard that's placed next to the phone in the prison that tells every prisoner that calls are recorded. And essentially asking, how could anyone be so dumb that they're actually doing something like this on the phone, knowing they're in the middle of trial and that they're being recorded? But James still won't agree. And now the judge is going to, and notice too, the prosecutor said it was on every call, every single call. So it's something that happened more than just one time. Now, James still won't agree, and the judge warns him that articles will come out. And then they finally publicly come up with a solution in order that they agree to. As of the close of this, nobody really knew what was happening.
Your Honor, he is not agreeing to the order.
Okay, well, does he know that in 10 minutes, there's going to be an article about it? Does he know that in 10, maybe 8?
So the judge is saying, if we get into this, there are going to be articles about this. Does he realize that? And they finally did reach an agreement, and that would limit his communications. So, and that's really pretty much at that point all we knew.
You want me to bring it in?
Yeah.
Okay.
Judge, I think we reached a resolution.
Sounds good.
Judge, I think I can just briefly make a record. This is obviously, the order is going to become public. The agreement is going to be that Mr. Crumbley's communications will be revoked, but not his ability to do research or otherwise participate in his own defense. So not just communicating with counsel, but his ability to read or get other information.
Okay.
Simply communications.
And
So-
that's going to be a stipulated order between you and Ms. Lehan.
Correct.
All right, and did you say that order would expire upon a verdict?
Yes, Judge. I think the issue is, once there's a verdict, a lot of the issues just fall away.
Okay.
Judge, it should go without saying, but I hope the court will encourage Mr. Crumbley that the conduct that's got us here.
I think I already did through his attorney.
Okay,
on several
thank you.
occasions, both in private meetings that we conducted. And I say private, I mean with both the prosecution and the defense.
And for the record, I've also addressed you, Your Honor.
I know you have. So I gave out free legal advice, Mr. Williams. So someone can take it or not take it, right?
So at this point, I would say the reason that nobody was reporting on this at the time, and that nobody really even kept the cameras in there or put that on their YouTube feeds, was because it was very confusing. I saw Sharon ask a question in the chat, and you're absolutely right. It was totally confusing. What did he do? I'm sort of taking you through how it developed. Today, more leaked out, though, and this leak came from the sheriff's office. Let me show you what the media was reporting today. Fox 2 reported that James Crumbley made threatening statements from jail, and that came from the sheriff's office, according to what they said. And then I believe this was, CBS News affiliate said James Crumbley made threatening statements over the phone in Oakland County Jail. All of that and that was what the judge was trying to warn about. The judge, everybody was trying to keep it really private, but apparently not the sheriff's office. And that's where the leak or the information came from that the media was reporting from. So they're saying that James made threatening statements by phone and in electronic messages. I don't know how threatening he could really be. I mean, what could he do from prison? The only two people I could even think of who would be in communication with him on a regular basis and who might have something to do with the case would be his wife and his son. And we were told at the beginning of the case that neither of them would testify. But for sure, you can tell from the way everybody approached it at that hearing that they took this very seriously. The prosecutor said something about this. This isn't just about stopping him from doing it in the future. It's about what he's already done. And the judge said, "Oh, I know." It was highly controversial. It's still not understood yet, but I guarantee you more will come out about this following the trial, at least. If not right now, it will break after the trial ends. They may contain it for now to make sure that there isn't any prejudice to the trial itself, but it sounds as if this is something very serious that the judge took seriously and that we're going to find out a lot more about. It sort of reminds me of the contempt hearing that we're going to be having coming up in the Troconis case, or the phone calls that got recorded from jail between Charlie Adelson and his mother, Donna Adelson. It reminds me of that. And again, it's an example of somebody not really thinking through the consequences of what they say in jail. So we'll be watching this absolutely as it develops. Now, let's talk about the opening arguments that happened in the case. I'm going to give you just a very few minutes from each side. The prosecution's was something like 4 times as long as the defense, so you'll get a bit more from them so you can understand, you can get a flavor for what the two sides are arguing. So the first thing that the prosecutor argued that showed he believed this gross negligence by James Crumbley was that Crumbley didn't use a lock for his gun. He gave a gun to a kid who was in despair and he didn't lock it up. Here we go. And trust me, there is disagreement about every single fact here, whether Crumbley even gave the gun to Ethan, you'll hear it all.
You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time.
The prosecution also argued that James Crumbley should have but did not provide mental health care for his son even when his son asked for it. Here's the argument that they make.
You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021. You'll learn that instead of receiving help or intervention of any kind, you see, James Crumbley was afforded what might
Let me stop it right there. And I saw a question run through from Leah about, do you agree that the prosecution should be able to have more than one theory? Honestly, I don't. I find that very strange. If the prosecution has a theory, I think all the jurors need to agree to it. I don't think they can agree to different things and still find somebody to be guilty of a very serious charge like that. That's just how it seems off the cuff to me. It doesn't seem right. The third thing that the prosecution argued was that, finally and most importantly, that James didn't act on the day of the shooting when Jennifer and James, the parents of Ethan, were called in to discuss a very concerning drawing that Ethan had made on his math homework. And they didn't tell the school, the prosecution argued, what they knew. Here's the argument.
The easiest, the most glaring opportunity to prevent the shooting. A full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son. November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley. You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. They kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6 Sauer 9mm.
So the state then went on to explain its theory for how James could be held liable. I want to stress that you do not have to buy their argument. You don't have to believe their argument. I just want you to hear it so you can at least understand what it is that they are arguing.
And I want to make sure this is clear. You will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th. That he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's two reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation in an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death.
One of the chief criticisms of the state's case against Jennifer and now James Crumbley has been that this is really a case about bad parenting, that it's saying you were a bad parent, therefore you should go to jail for murder, or at least manslaughter. So I want you to hear the state's explanation for why they don't think that's a fair critique.
This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids' things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do, that is when that rare set of circumstances is present in these specific set of facts. James Crumbley isn't charged with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th.
So the prosecution went on to argue that this isn't about guns either. This isn't just us trying to go against guns. Now, here is what the defense, pretty technical approach. This wasn't an argument that the entire concept of holding parents is wrong. Holding parents liable for what their children do is wrong. It wasn't big in scope like that. They went pretty narrow. I want you to hear what they said next. And remember, theirs was pretty short, so your clip is short
Ladies
too.
and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access is not allowed. In James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know.
So, and Honestly, of the cases we've ever covered on the channel, this is probably the most important because it actually hits a nerve, something really important in our society about what we believe about the liability of people who are charged with crimes. And so it's important. I didn't cover the Jennifer Crumbley trial, and I was not going to cover this one, but that was probably a mistake. And the reason I wasn't going to do that is because I'm not neutral here. You know that I try to be neutral on the channel. I don't feel that way about this case. I don't feel remotely neutral about it. So it will be a challenge for me to present it, and I hope I can do it fairly and that you can all be able to make reasoned, fair judgments by hearing both sides of the story. And so that's my goal with what I present to you. So let's get into what happened with the trial. The witnesses and the explosive text messages that we heard about. The first witness out of the box was Molly Darnell. And let me add to the stage. Not sure, I think that might be it. Okay, yes. Let me show you this. This is Molly Darnell, and she was the International Baccalaureate Coordinator and English Language Arts coach at the Oxford Community Schools. And she was at Oxford High School that day. And her testimony was really mesmerizing. It was about the day of the shooting. It wasn't specific to anything James did. It was about the day of the shooting. She explained that she was sitting in this office where 3 teachers worked, and there were 3 teacher desks in there, and the door was open. And she saw kids running through the halls. She said she'd never seen people run like that before, ever. They were utterly silent and just running frantically, intently down the hall. And then the silence was broken, and she heard 3 things, she said, really close together. She heard the announcement bell come on, and the principal said the school was going on lockdown, and this is not a drill. Then she also heard a pop, pop, pop. She said it didn't sound like gunshots to her, but she said she really wasn't all that familiar with how a gunshot sounded, so she couldn't really be sure. And then last, she heard the sound of multiple doors slamming as teachers and students barricaded themselves in their rooms. Next to each door is a night lock, and you can slide it into place at the bottom of the door. And then even if the glass on the door gets shot out, no one can open the door. So she's about to slide the night lock into place to bar the door. And she looks through the window. She's right over there at the door. She looks through the window, and she is eye to eye with a boy in dark, baggy clothes and a skull hat. She can see his eyes. She notices he's wearing glasses. She locks eyes with him, and suddenly out of the corner of her eye, she realizes that something's moving. And that's the moment when she realizes he is looking straight at her into her eyes, and he is raising a gun and pointing it at her. She remembers thinking to herself, there's no orange tip on it. She had heard that BB guns have orange tips, so that would mean this wasn't a BB gun. It was the real thing. She felt hot water on her arm and notices a bullet hole in the glass leading to the courtyard, but she has no idea that she's been shot, and she's terrified. She wanted to barricade the door, but she's scared to go near it. She shoved the filing cabinet over to barricade it, and then she dropped the night lock in. And it occurs to her that he could come to the back window. So then she tries to crawl behind the filing cabinet. And as she's hiding there, she notices that her arm's bleeding, and she tries to use her own sweater as a tourniquet. And she wanted to reach for the phone that was over on the desk, but she knew that if the shooter was still standing there, he'd be able to see her as she went over to the desk. She did, I guess, have her phone with her. She texted her husband, "I love you, active shooter." She texted her daughter that she was sheltered in place. "I'm safe and I love you." And she texted other teachers, but she didn't tell any of them about her gunshot wound. She said she figured she wasn't the one who had an emergency. She said the silence was just deafening. There was one more announcement telling everyone to remain in lockdown. And then after what seemed an eternity of fear, the police came and escorted her down the hall and to the hospital. And there she is. She was very emotional testimony. And okay, I guess there was a picture of her being escorted down the hallway, simply of her walking with 2 police officers, which I guess I don't have up for you. But when they went back, she was treated, of course, at the hospital and released that same afternoon, I believe, or evening. And she said when they went back and she looked at the door of the room where she had been, the scariest part was that the gunshots were right where the shooter had tried to hit her in the head and the chest and had just missed. So for obvious reasons, James Crumbley's lawyer had no cross-examination for this witness. The next witness was Edward Wiegrowski, who spent 28 years with the county sheriff's office, retired from there, and for the last 2 months is now with the U.S. Secret Service. He looks at cell phone data and is a forensic computer examiner. But this wasn't sort of the ordinary dry testimony you get from most experts in cell phone forensics, because Wiegrowski had been actually called to the scene on the day of the shootings. He had a 17-year-old daughter, I'm not sure if she was 17 then or is 17 now. And he talked about the children who were dressed just like his daughter would have been, pouring out of the school with no coats on. And he was still very emotional about what he had seen that day, which was very understandable and relatable. He was, in short, an absolutely ideal witness for the prosecution. And he described his first look. He's looking at the videotapes, the school videotapes. That was his job, was to collect all the video the school had. And he's looking at the shooter coming out of the bathroom wearing dark clothes with his shoulders back and a proud chest, he called it. And then just watching helplessly at what came next. And it was intentional and it was horrific. Finally, the shooter went back into the bathroom and another student came running out of it, running for his life. The shooter then came back out and 2 deputies walked toward him. He watched the shooter on the run back of the video put his hands up in the air and be taken into custody. And then the witness went through a series of text messages showing that the Crumbleys were very concerned about Ethan in the months before the shooting. And I'm going to show you some of those. 8 months before the shooting, on March 8th, Jennifer was at work and James was at home. And Jennifer was frantically texting James when Ethan didn't show up. Let me pull that up on the screen for you. Give me just a second. There we go. 7. Okay. So Jennifer is in blue. That's the mother. And the green, James, who's on trial, is in the green. So Jennifer says, does he have his phone? And then the dad, James, who's on trial, says, yes, but he won't answer while he's walking. I'll let you know the minute he walks in. And she says, I'm serious, freaking out. Is he home yet? So she's obviously very worried about him. And we see in next conversations, she sends another freaking out. He says, he does not get home till 3:16. She said, I told you to pick him up because he's upset and I don't want him to do anything stupid, expletive. And then Green, the dad says, dude, chill. He is fine. And I'm trying to effing work. So but obviously Jennifer's very concerned about her son. This is in March. The shooting is November 30th. Months later, about 8 months later. So a decent amount of time between them. Now, later that same month, on March 19th, Jennifer writes to find out how Ethan is doing. Again, she's at work and James is at home. Apparently, a really bad incident, which we don't know anything about, happened the night before. So let's take a look at those messages. Jennifer, and this was how it was projected. It's kind of crooked like that. Ethan awake. This is the next morning after the bad evening. And James says, yeah. And Jennifer says, how is he? And then James says, he woke up looking like he had way too much to drink last night. It's hard for me to read this. Sorry, complaining about a headache. And then the mother says, well, he was really worked up and out of control, so I can see why. And then adds, all I know is he needs to eat, go to work, and work hard and not complain, and he can get his stuff back. And so that was more concern that same month about Ethan. But probably the most disturbing texts were the ones that Ethan sent to his one and only friend. Now, do any of these necessarily make James liable? Do they mean he should be convicted? No, I'm taking you through the evidence. But the friend and Ethan texted obsessively. There were 20,000 messages, the witness explained, between January and the middle to end of October. And then it was abruptly cut off when the friend was sent to a program for his own problems. So some of these were deeply disturbing. Let me show you what was said on April 4th. So Ethan writes, his friend says, like, I hear people talking to me and see someone in the distance. And he corrected the spelling of distance. And then he says, and the text messages go, it's over 2 nights, overnight because it's around midnight. He then says, I actually asked my dad to take to the doctor yesterday, but he just gave me some pills and told me to suck it up. Like, it's at the point that I am asking to go to the doctor. It says got the doctor. It said, my mom laughed when I told her. Now, do we know that these things are true? No. This is the evidence that was submitted at trial, and so it's what the jury will see. And then these are only Ethan's side of the text, and you can see the asterisk marks, which suggests the friend responded. So there was back and forth, but that was pulled out. But I'm having bad insomnia right now and paranoia. I need help. I was thinking calling 911 so I could go to the hospital. Again, it says got the hospital. And then you see something from the friend, but then my parents would be really pissed. And he says, and this is all on that same overnight, April 4th to April 5th. I am going to ask my parents to go to the doctors tomorrow or Tuesday again, but this time I'm going to tell them about the voices, like I am mentally and physically dying. So really disturbing, brutal comments. The text messages between Ethan and his friend were by far the most disturbing. And then you get closer to the day of the shooting. On November 26th, 4 days beforehand, Ethan posted to Instagram showing a video of holding his new gun and saying, I just got my new beauty today, 6-hour 9mm. Ask any questions and I will answer. And the cross-examination focused on the fact that on these text messages, there really wasn't a lot of context. These were pulled out, and of course the witness didn't really know what the context was. He could just read the words that were there. And that was the majority of what I think the cross-examination was about. There was also a message from the friend's father, a message back and forth between the two dads. And James wrote the dad and said, hey, Ethan's trying to get hold of your son and not hearing from him. Is everything okay? And the son's father said, well, here's what's happened. We've sent him off to a program because he's been having a lot of trouble with his obsessive compulsive. So we've had to do that. And so that's why he isn't responding. And so, and Asadab, please say nothing about this until let the friend tell Ethan when it's time. And so that's how, and I thought that actually made James look like a pretty good, involved dad, that when he heard that his son wasn't hearing from his one and only friend, he tried to intervene and do something about it to protect him. But he wasn't able to do that ultimately because the boy was sent away. And it was that October period when the friend was sent away and they stopped being able to have some communication with his one and only friend, that it was at that point that Ethan plummeted and that things went really, really badly for him. So as I mentioned, the there was the next witness was Robert Cotels, who talked about the evidence found at the scene, like the casings, the bullet fragments, and of course the gun. And he testified that the shooter fired 32 times, plus had 18 unfired bullets, so a total of 50 rounds. The next witness was Cammie Back. She was the office manager for a retail store that sells firearms. And she talked about James Crumbley buying 2 guns at the store. The first gun he bought was in June 2021. And the second one was the one that Ethan posted was his gun on the Instagram. And it was the one used in the shooting. The store is required to offer a form showing that they provided a trigger cable lock for the gun. And James actually signed that for both guns. The prosecution notes that the trigger lock never got taken out of its package at the time of the shooting. James also signed documents saying that he was buying the gun for himself, which, when certainly family social media posts suggested it was really a gift for Ethan for Christmas. And the defense said that James didn't know that Ethan had access to it. We haven't heard exactly what they mean about that, but they may be suggesting that James hid the gun thinking it was a Christmas gift, and this was still November, so he wasn't going to give it to his son for a while. So the defense on cross pointed out that a minor can temporarily possess a handgun under some circumstances, such as target practice, and there's no evidence that James allowed his son to possess a gun. So there's no law, they said, that you have to use the cable lock. You may have to be given one, but you don't have to use it. And the prosecution had sort of hinted that maybe the sale to James was delayed, which kind of left the impression that maybe he had some problem in his background that they had to go around in order to give him a gun. But the defense pointed out that the box was checked, saying that there was no federal problem found, that it was cleared with the federal government. He also didn't purchase any ammunition with the Sig Sauer gun. So let me head over. Thank you, Fatica, saying loves your analysis. Thank you. I really appreciate that. And Ada Shaw says agrees with everyone. Your analysis is needed and appreciated. Thank you. I really appreciate that, especially since I had all the trouble earlier. And Pumpkin Porter, you worked so hard for us. Thank you for all you do. Thank you. Y'all are a very, very kind group. I'm very fortunate to have you as the group, as the people who show up and watch regularly. Thank you immensely. So I am ready to do a few questions. And so I will head over into the chat and look for that. And Cutley is happy to make a live show. Great. I'm glad you are here too. So, okay, if you have questions, if you could put a question mark at the beginning, it will help me spot the question more easily in the middle of the chat, because different people, people will be making comments at the same time as questions. So I'm curious about what you think. And thoughts on the article and threats. Mandy Kirk wants to know. So I have to agree with the judge. It's astonishing that anyone would do that, given the fact that there is the sign there warning you that you're being recorded. And during a trial, they absolutely are listening to every single thing you say. In fact, Charlie Adelson and Donna Adelson's recordings were after he was already convicted, but they are intensely watching all of that. So it is astonishing that there would be anything like that. I really can't see what it could have meant or who it could have been, other than the only 2 people I can imagine who would listen to him, which would be Jennifer, his wife, and Ethan, his son. If they're allowed to communicate, then I would assume it would have had to have been one of them, but they aren't testifying. Ethan's case is on appeal, so he really wouldn't be allowed by his attorneys to testify. Did he maybe want him to come and say, hey, it was all my idea, I stole it, Dad had no idea? Maybe, but there just was nothing around it to explain it to us. So we don't really know what it said. I think it's going to be, there will be follow-up. It's not going to stop right there. We're going to learn more about it. I suspect we won't, well, I don't know. We may well learn more before the trial is over, but Ideally, I think the court would prefer that we not learn about that until after the trial, because the court made such a point of trying to keep it all confidential, of trying to avoid a bunch of articles that said James Crumbley is threatening witnesses, wanted to avoid that, and then ultimately could not do it. And that seems to be because the sheriff's office released it. Maxine wants to know about whether I feel this will set a negative a negative against parents who make honest mistakes with their children. And so, Maxine, that really gets straight into the controversy that we talked about whether or not this case is, that's why it's controversial. Because one side says, hey, this prosecution says this is an unusual case because the parents here had special knowledge. They had opportunities that they didn't take to have stopped this. They were grossly negligent. It was more than just they didn't do a good job. So that's the prosecution. And there is the defense side and many other people who believe that it is wildly inappropriate to prosecute parents for what their children have done. That we, as a Western society, separate those things. We prosecute individuals, not families, and that this is more of a prosecution of a family, and it's a slippery slope. If you start with the, quote, really easy, really different case, this is so unusual, it's so rare, then it gets bigger and bigger. So those are the two sides there. All right, Kelly is asking me which side. Oh, see, this is a high compliment, Kelly. She says, when you say you're on one side of this case, which side, I can't tell. That is a high compliment. Thank you. JK Men, what makes us different legally than bartenders being held liable? I didn't mean to put that up there, but then bartenders being held liable. Sorry, JK Men. Bartenders being held liable for serving someone too many drinks who then drives drunk and kills someone. So this is a theory of liability that isn't limited to this case. The idea that someone could be liable for promoting or prompting, but rarely would the bartender be held criminally liable for serving too many drinks to someone who drives drunk. There's a possibility that that could happen, but typically that would be a civil case. Someone would sue the bar and say, you served too many drinks and therefore we're going to sue you and you owe us money for what we've lost as a result of the wreck, or the person we've lost, the person who died in the wreck. But these are all the principles. You're exactly right. The principles are the same that are applied there. Maddie B wants to know, how are Ethan's texts allowed as evidence? Early on, like before the trial even started in the morning, the judge ruled out a couple of text messages that were sent between Jennifer, the mother, and Ethan, because it was just the two of them communicating. So then anything that Ethan sent to his dad was allowed in. Anything that Jennifer sent to the dad was allowed in. And then Ethan's text messages were allowed as evidence. I guarantee you that was controversial, that there was an argument that Ethan's text messages to his friend should not have been allowed in. But because they reflected his state of mind, I suppose is the reason that it was allowed. I don't know the exact hearsay exception that the judge used to let those in. Jerry Michael, how liable should the school be for not insisting that the shooter be taken home since his dad was home? That was, Jerry, one of the other huge controversies in the case. Early on, there was some controversy, some complaint about the fact that the school didn't act immediately. The school had the picture that he drew, and the comments that he made, and yet they allowed him to go back to class and they allowed the parents to leave. Parents said, we've got to go to work. We can't take him home. He'll be home alone. And that was explained that he would have been home alone because both parents were going to work. The prosecution said, well, James was just doing DoorDash. He hadn't even signed in yet. He did sign in within 3 minutes of the time he left the parking lot there at the school, but he didn't have to sign in. That was the argument that the prosecution made. And the defense made the argument that, hey, being a DoorDash driver is a real job. Just because you don't think it's real doesn't mean it's not a real job. So back to your question, though, how liable should the school be? There was controversy about the school's role in this. And the prosecution was careful to point out that the school was concerned when the parents said, if we send him home, then he's going to be all alone. And the school didn't want that. I would imagine that also was important to the parents. Nobody wanted Ethan to be alone. I wonder if they thought that Ethan was more interested in self problems rather than being cagey with my YouTube words. But if he was more interested in that than harming other people, they may have assumed he was just interested in, he was depressed, that he was upset and it was turning inward. But it was definitely, or especially early on, it was a real concern was how the school had responded and whether the school had responded appropriately. Xana wants to know, what do you think he and his lawyer will be doing differently, knowing Jennifer was found guilty? Good question. And we don't really know. The one thing I can see is they didn't seem to really be making sort of the bigger argument that this is about parents. They may well make that argument by the time closing argument comes, but for now, they seem to be more focused on sort of the technical question of what James knew or could have expected or anticipated based on his knowledge about his son. Okay, Lisa, I'll do maybe a couple more questions. If this is a manslaughter charge, why no bail? I can't answer that, Lisa. I don't know the answer, but they have been in jail for a significant 2 years, I think, basically. I guess it wouldn't be quite 2 years, or would it be? Anyway, very long time. I wasn't born with thorns, wants to know reporters. I'm not sure your question. So just reporters question mark. I'm not sure what you mean by that. Skylar, shifting gears, when will we cover Jennifer Dulos and her whereabouts? Okay, good question, Skylar. I talked about that, and here's sort of how I got several messages from y'all, really good, thoughtful messages about some of your ideas about that. This is kind of what I've been thinking. That requires, I mean, it's sort of more speculation. My plan was to look at the facts that we learned and apply that just logically. Where could the body be? What could have happened to Jennifer based on facts we learned at trial, and make it very factually based. But here's what I've been thinking. I think what I'm going to do is do a special live chat for members only, where it's a pretty small group. And I want to kind of talk through it and get some input and thoughts from y'all, because I feel like I needed that. I didn't feel like I was quite ready to do that video yet. I felt like I needed a little more work. So that's what I'm thinking is that it'll be a members only live chat. So it'll be a little bit smaller group, and I can kind of see what you're saying and respond to that. And you can kind of help me think through what the issues are on that, because I too remain very concerned about the fact that Jennifer Dulos's body was never found. It's just a tragedy, and especially a tragedy for her family. Lenore Forevermore wants to know, do you think there is any real chance he will be found innocent considering Jennifer's sentence? What would be different? And Lenore, it's very rare for anyone to be found not guilty in a criminal case. Just the statistics are extremely high for conviction rate. So that's just, that going in. If you're going to be a betting person, just go ahead and bet on guilty, because it's very safe. You'll see lawyers on these shows be interviewed. What do you think the jury will say? And they always say, probably guilty. And that's because it's safe. It's really safe to say that. That's just statistically how it happens. There are cases where it's so controversial, and this is one that anything could happen. But if you're a betting person, if you look just at the stats, you are right. It's likely that he would be convicted. And Phil wants to know, what are my thoughts about how James's lawyer conducts herself? Everything I've seen so far, and remember, I haven't seen the afternoon if something wild happened, but is that she's been professional. And so I don't really have any comment on that yet. I haven't seen anything that sort of shocked me or stood out to me that would make me have an unusual comment. And you may be comparing her to Jennifer's. I did not watch Jennifer's trial, so I can't really do that. I did watch little clips that got put out, but that's probably not a very fair representation, so I'm not going to base any statements on that. So, oh, thank you, JK Min, who gifted a lawyerly membership. I really appreciate that very much. Well, I will see you all again on Monday at 7 p.m. Eastern. I want to thank all of the members. I want to thank all of you who have hit the like button, who have subscribed. It means a great deal. I want to thank Marlon and Mama Pinks, the moderators. We're not going to have our usual outro today because, of course, I lost that when I had to leave and then come back. So my bad, but thanks for watching, and I'll see you Monday at 7 p.m.